It's going to be a little late if you want to wait and pass through. So we're start with Phillips, Reagan.
Reagan Phillips, Your Honor,
Reagan
22
Phillips,
CF 36.
Last minute ad, so we'll do that one.
Judge, we're asking the court to modify his bond. Mr. Salas has been interviewed and accepted into vet court, and the state's okay with that. But we don't go back to vet court until August 12th. So we'd like to go ahead and have the bond reduced. We're asking for the court to consider maybe something as low as a $10,000 bond, but I understand based on the charges, the court may want to go higher than that. But I think currently, and the state did tell me this morning that one of the cases they did not file on, well,
One of the counts.
okay. So I guess there's really $105,000, no, I guess $155,000 bond currently. So we're asking the court to reduce that drastically.
Judge, for the burglary with assault or battery count, I think $25,000 cash professional is appropriate. And for the misdemeanor battery, I think $1,000 cash professional is appropriate. I would ask the court impose the pretrial services if he qualifies for that, with the conditions of the victim wishes to have no violent contact with the defendant. He should not possess any weapons, drugs, alcohol, and he must comply with vet court. So the victim wants him to get help with his PTSD and mental health issues. She does wish to have contact, just no violent contact. I'm showing his criminal history as one prior misdemeanor, and he has no prior failures to appears.
Judge, I'm just asking that the court consider maybe a little lower than that. Dad's one who retained me, and Dad will be the one having to come up with the money to pay the bonds, but I don't believe there's going to be a problem with him appearing or not appearing. But I certainly understand the state's position.
These are very serious charges. Court will come down just a little bit to $15,000 and $1,000 bond. Importantly, though, is to work with the pretrial services, no violent contact. That allows you to have contact with the victim. You can't have violent contact anyway, but it just kind of puts an additional burden. No weapons, alcohol, or obviously non-prescription drugs. Anything else that we need on the pretrial services?
Just to comply with vet court, Judge, and I think that's it.
Obviously, vet court, you've had that explained to you. It's a very fine program, and it's an intensive program, but hopefully it'll have a positive effect. I mean, but a lot of it has to do with you. So.
And also, Judge, if we could make a condition to take any medications that are prescribed.
Take medications as prescribed. You good with that?
I'll prepare an order, Judge.
Very good. Thank you very much.
I'll call you Dad.
Yes, sir. Thank you.
Brandon Scarborough.
Judge, Mr. Scarborough's case was simply put on the docket today so that we could keep the court apprised of where we're at. I did get a report yesterday evening or yesterday afternoon from Dr. Harper. I've got to have some time to review it with my client. I've not had the opportunity. So I think we're currently set for
822.
8:22. So maybe just leave it set for 8:22.
Okay,
And
very
we'll
good.
tell you where we're at, okay?
We'll just come back on 8:22, and then we'll do that. Make sure and stay in good contact with them between now and then, so we can kind of figure out where we're going, okay? Okay, thank you very much.
Get my office to call you, set an appointment. Judge, then I have Mr. Robertson that's in lockup.
Nolan Robertson. Go ahead and announce those case numbers, Mr. Noakes.
Yes, sir. We've got
19 CF 1582 and 20 CF 127.
Yes, sir. The state and I have agreed that Mr. Robertson this morning is prepared to admit that he violated his probation by a new arrest for operating a motor vehicle without a driver's license, which is a second-degree misdemeanor. The agreement with the state is that the court would continue to withhold adjudication. His probation would be reinstated with the next 6 months of his probation being that he'd serve that as community control, and there'd be a $100 cost of prosecution. May I approach?
Thank you. Okay, go ahead. That's all right. State in agreement.
Yes, Your Honor.
Get you to sign this, too.
Thank you. Mr. Robertson, would you please raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Okay.
Mr. Nopes, you're in agreement on the score sheet?
Yes, sir.
Okay. So you heard your attorney state the terms of the agreement for this violation of probation. Is that your understanding of what the agreement is?
Yes, sir.
Have you kind of gone over this? Importantly, in this case, obviously, it's a favorable outcome. You're continuing to withhold, you're continuing on probation, except there'll be 6 months of community control. You've kind of gone over in detail what community control means, house arrest. You understand the sequence, generally it's, some lighter probation, community control. You kind of got that sequence, don't you?
Sure.
In other words, I'm not trying to, threaten you, I'm just saying, focus on this, stay in good contact on this, follow the rules and get through this. Because if not, the next step is probably not going to be positive, okay? I want you to be successful, that's what I'm telling you. But you got to do your part, okay? You understand that by entering into this, you're waiving the right to go to a trial, you can contest all this. You believe this is in your best interest?
Yes, sir.
Okay. Based upon that testimony, the court will accept the plea of an admission to the violation of probation, continue withhold adjudication, continue on probation. Is that how we're stating, continue on probation with this next 6 months?
6 months on community control,
Correct.
followed by the remaining period on probation, I assume.
That is
Okay,
correct.
thank you.
Okay? Is that your understanding?
Sir.
Okay, very good. Okay, thank you very much. Meet with, does he need to meet with you? Okay, go ahead and meet with probation. I like this, this is good. Oh, that's good. Okay. Porter, Janice Porter. Sorry to make you come all the way over here from thing, but I just hate having to, just don't know what's going to come up and where we really need to do this. These are important cases.
Understand completely, Judge. Paul Gillespie for the state, and it's case number 20 CF 2327. Judge, we were set for status today.
Correct.
She had entered a plea previously.
Right.
Where we are at this point is I've received documentation, I believe yesterday or maybe it was Tuesday or Monday, that they have listed what I believe is a therapist. I don't have any other documentations or evaluations or anything of that nature. I'm going to need to get those from them if there's going to be an evaluation done. If not, we need to talk about that and set a deposition for her to see what she's going to say, because I can't get another doctor unless I know what she's going to say. I spoke with probation about the issue of the PSI. There was questions about that. They had indicated that they required an order. That's what I was told. I haven't followed back up, but let you know that they were mentioning something of an order from the judge on a PSI. That's what I was told on Monday, I believe.
We need an order to order the PSI, didn't we? We ordered it in open court, but we need a written order?
I didn't think we ordered it. I thought they were talking about it, and y'all were waiting on a mental health evaluation?
Well, we were, but I do want to have a PSI. So do we need to do a written order?
No.
Okay,
Ordering it right
just as
now.
long as we're clear. If we weren't clear last time, it's my bad. We need to be clear on these. Where are we at with these? This case has been going on for a long time. We've had a plea. There's,
Understood, Your Honor. And David Rare filling in for Mr. Lupella this morning for Ms. Porter. In addition to the state's scheduling matters we do need to address regarding the therapist, we've listed depositions and materials on that. We did want to discuss this morning the court's scheduling matters when we can come back on sentencing or a status hearing to try and resolve the case.
why don't we schedule a sentencing and get everything done between now and then? How about we
Understood,
do that?
Judge.
Yes, Judge.
In order to get
I
a,
mean, we should have scheduled the sentencing before. As an accommodation, we waited to come back here to do this, and now it seems like we haven't really made a lot of progress. That's why as far as getting these. So there's been one witness listed. Is that your only witness?
yes, Judge.
That's okay, if that's all right. Okay. And so you need to schedule a deposition?
Yes, for
When
sure.
was that provided?
I believe it was provided Monday or Tuesday.
Okay. So
But-
what I would suggest is we just go ahead and schedule the sentencing with the understanding that the deposition be done, in the interim.
Understood, Judge.
Is that good? I mean, is there anything else that we need to do?
There is one issue, Judge.
We need to
if-
make sure and provide the probation sufficient time to do the PSI.
Just let me know what your sentencing date is.
Okay, well, approximately how long do you all need? That's kind of the most important.
I think there's a lot of information, and it's going to be in hers due to the amount of transactions, if you will.
Right.
If you could give us at least 60 days.
Okay, that's fine. So,
We're not going to be able to, yeah, if needed.
let's see, that would be. October 27th,
Okay, thank you, Your Honor.
does that work? In the afternoon? How long do you all anticipate this sentencing? Hour, 2 hours? Could it be longer?
From state judge, I would think an hour. I think maybe 3 witnesses, maybe 4 from
Okay,
state.
so it's a couple of hours. I'm just letting the clerk know so we don't schedule,
Right. In the abundance of caution, I'd probably say at least 2 hours, Your Honor. It doesn't seem too
That's
short.
good. I'll kind of put it down for 2 hours.
Understood. And Judge, there's one more matter just to make sure there's no further issues with scheduling. Could we approach the bench?
Sure. court will go ahead with the October 27th. And the only thing I would finally ask is if there is any movement on that, please let us know as soon as possible, because, and I know we may not, but I mean, even if it's like a month or, because that's a block of time, that's a 2-hour block of time, it's a key motion docket in the afternoon. That's when we do our more substantive motions, and if we use a 2-hour block, it'll be hard, we'll be having to push other ones, so try and utilize our time as best we can.
Yes, Judge, Your Honor. Thank you.
Thank you, Your Honor. That's all I have.
Thank you.
That's all I have, if I could be excused.
Thank you. Counsel, come here.
Sorry.
Morning, Your Honor. We are here in State of Florida versus Vicky Acevedo, 21 CF 949. And we have a written offer of plea, if I may approach, with a corresponding score sheet.
You may. Good morning. Thank you. Would you go ahead and announce the agreement?
Judge, at this time, Ms. Acevedo would plea as charged to the 2-count information, count 1 being sale, manufacture, deliver, or possessing with the intent to sell, manufacture, deliver a controlled substance, a second-degree felony, as well as the use of the two-way communication device to facilitate a felony, a third-degree felony. The agreement would be that there would be a withhold of adjudication. She'd be sentenced to 2 years probation with the Florida Department of Corrections. Concurrently, there would be a $41 cost of supervision imposed, fines, costs, and fees in the amount of $765. As a condition of probation, she would abstain from any drugs or alcohol unless she has a valid prescription, subject to random urinalysis, and she would take or complete a substance abuse evaluation and comply with any recommended treatment if there is any. She is a resident of Orange County, so no objection to transferring her probation to Orange County after she reports here today. Right.
Would counsel approach?